Elizabeth Townsend for Dean Massaro's Preparing for Lives in the Law. It is November 26th, 2001, and this is Richard Davis. We're going to start with the first question we ask everybody, which is, why did you go to law school, and was it what you expected when you got there?
Well, law school was kind of unexpected with me. I was attending the University of Arizona in graduate school. I planned to become a college professor. I was going to become a teacher. And during my junior year, I met a man by the name of Chuck Ayers. And Chuck was a professor at law school here, and he and I had a conversation, and I don't know if you know Chuck Ayers or not, but he's one of the truly good people. And he was very interested in trying to improve the diversity of the student body at the University of Arizona College of Law. And he talked to me, and after talking to me, he asked me to check my grades or if I was interested in law school. We talked, and fortunately, I was doing okay as a student, and he looked at it and told me that I was close to being an automatic admission if I wanted to go to law school. So he talked me into taking the LSAT, and I did. I did fairly well on it, and then I decided, once I had done all that, that I had a chance to go to law school, and I did. But before that, I had no inkling, no idea that I'd be going to law school. So if I want to blame somebody for me becoming a lawyer, you can blame Chuck Ayers.
How did you meet up?
Well, he saw, and I know exactly how. As a matter of fact, it's one of the things I've always, it's one of those things where we met, we became, and I was more thrilled with the fact that he was my friend than how we became friends. But as I understand it, one day I heard that there was a man who wanted to meet me. And I said, fine, I'm willing to meet anybody who wants to meet me. And we got together, we talked for a period of time, and before I knew it, I was allowing him to check my record, and I was taking the LSAT. And after that, everything went according to what I expected. I don't mind telling you that my first year of law school was, my first semester, really, not year, was not the best in the world, but there's a reason for that. I had a couple professors, Chuck Ayers being one of them, who worked with me and looked at it and said, Richard, I see you in class, you do very well. I know what your problem is. You don't know how to take a law school exam. And so I worked with a couple of professors. It was one of those things where I said, here's your paper, do it again. And I did it. I got it back and said, do it again. And from that time on, I was on the dean's list. So the bottom line is that I've always had good people who've been willing to help me out. And law school was really not that challenging after that.
What was it about? I mean, students will be very interested to know that part. Sort of, and I personally, I struggled a great deal with the first semester and didn't do as well as I had hoped. What did you think with doing the exam that way? Oh, what did you learn? What is it about taking an exam that you have to understand?
Organization, issue identification. I think it's very clear. For example, if you're taking a class in torts, I've always remembered something that I kept in the back of my mind when I'm going to take an exam in torts. Negligence and actual negligence are distinguishable terms. In order to have a case in negligence, you have to have A, B, C, and D. And if you do that and develop it and then develop the issue into it, you're going to do well. It's simply a matter of organization. And I can tell you that that was very helpful because I use that same concept today.
In what way?
Well, when I'm writing, I still think that for whatever reason, there are a lot of people who think that volume is the key. I don't. I think that getting to the point is the key. And if I have a specific issue, identifying the issue and getting to it quicker is better because the average judge is not going to read 15 pages, but he may read a page and a half. So I think the key to the whole thing is letting people know that you know what you're talking about, that you can identify the issue, and that you can provide a solution to the issue. And the sooner the better.
So do you think then law school exams, the ones that are essay, that there's a good reason for people to be, some people say, like, what's the point of these exams? Do you see that it correlates to, obviously you just said that, but I guess multiple choice exams, for example.
Well,
compared to that,
It's a tough question, and the reason is that we come from different cultures. When I was in law school, it was all essay exams. There was no such thing as an essay, as a multiple choice type exam. So I only know essay, and I think that's important because the key to practicing law, in my opinion, is to being able to identify issues. And if you can look at a set of facts or anything else and identify what the issue is, I mean, what, after all this, after reading everything else, you're going to be able to look at someone and say, this is going to determine the outcome of this case. I mean, that's really what it's all about. And if you can identify an issue, and if you identify general areas of the law, you're going to do well. And it seems to me that that's what this is all about. I'm a trial lawyer. Some folks go in thinking that they have to prove 10 or 15 things. My belief is that every case hinges upon a very few, very simple issues. And I think the lawyers that do well, particularly trial lawyers, are those that can keep it simple, get to the point, not waste time, because you have to remember, juries walk in the courtroom, they get bored. I mean, they sit around, they do whatever, and I make it a point of saying that I need to make a point, but I'm going to make it, and I'm not going to bore you with it, I'm going to sit down. I have a rule of thumb that very few cases require more than 17 minutes to a half hour to present an opening statement. I don't care how complicated it is. Arguments are the same. I mean, you're dealing with the attention span of individuals. You're dealing with your ability to get an issue across. And I think that if you can keep it simple, you're going to do better. And so if you have a case involving negligence, if you tell someone you know what negligence is, that's why I go back to it. Negligence and actual negligence are distinguishable terms. In order to have a case in negligence, you have to have a duty, a breach of duty, and so forth. And then you progress down the line and you've told them all you need to know. And we can talk for days, but the important thing is if you look at that, you know that number one, I know what I'm talking about. And number two, if I can now bring the issue within here, I mean, is the issue here duty? Do I have a duty? Or is the issue here causation? Either way, you're getting your point across. And I think, at least in my way of thinking, you're a lot better off to keep it simple. And that's what I've done, and it's worked very well for me.
Did you always do that? Did you always have that philosophy?
I had that philosophy after my first semester in law school, yes. I'll tell you a story, which case in point. Now, I don't know to what extent you're going to use all this, but I represent a lot of people. And at one time, I represented the board and chemical company. And obviously, they have their own house counsel, they have out-of-state counsel. And at the time, we had a couple of twins in town called the Rawson brothers. They were very good judges. And I prepared a motion for summary judgment. And the motion was a page and a half long. I sent it to my client, who wrote me back and said, this is totally inaccurate. They sent me a motion, 25 pages with attachments and so forth, and they say, file it. And they actually flew it down to me. My secretary went to pick it up at the airport the day I argued the motion. I argued the motion, it was granted before I ever got there. So the bottom line is that, if you have a point to make it. Judges appreciate that. And it doesn't matter whether you're doing it a page and a half or 15 pages, as long as you get your message across. And like I said, the shorter, the more apt the judges to read what you say.
What about people, especially just starting out, afraid that you're going to miss something or say the wrong thing, or that's why they put in so much stuff?
I understand that, and I believe that is probably the biggest failing of young lawyers. I have young lawyers working with me, and I think that's what people do. I think not only young lawyers, a lot of lawyers do that. But I think that what, in my opinion, is controlling is, like I said, the ability to look through all of that, material out there and determine what factor or what factors are going to be the ones that make the difference here, and that's what you do. You concentrate on that. I've never worried about that, and it's not that I think that I'm so good. It's just that I think that you have a role to play, and I think that at some point in time you have a confidence level, and it's worked out fairly well. But again, I think that you can only do so much, and most cases will hinge upon 1 or 2 or 3 facts. And I think when you go to 12, you're diluting the 3 that you're trying to concentrate on, and that's my philosophy. Yeah.
Do you think that philosophy differs from the people that you see around, or do you think that it's? I mean, do you mean is it a philosophy that? How does it compare to when you're against other people?
Well, I try to contrast myself with other people. I just finished a trial last week or 2 weeks ago, and one of the things I try to do is, I mean, if my opponent, take an hour and a half was opening, I take 15 minutes. In closing, he went for about an hour and a half in the original closing. I do mine in a half hour, and then he comes back for another half hour. The point I'm trying to make is that you have so many things to say. And I think you make a mistake if you try the entire case with a single witness or with a single argument. I think you have to, go through it. You have to pick out the things that are important, and you have to make that point. And I think if you do that, you're going to do okay. But like I said, juries sit around. They think people waste their time. And I do certain things which I think try to minimize that. For example, when juries come in and they're picked, they sit and they don't know who's causing it and so forth. So I make it a point of getting there early and standing in the door so they know that I'm there. Point, they know they're not waiting on me. When I have a point to make, I make it and I sit down. I don't have to say the same thing 4 or 5 times, as long as I say it once effectively. If it's important, I may say it again just to get my point across. But by the same token, I've yet to see a case won because someone won on every point that's being presented. It's selecting the important things and zeroing in on it and making the point.
And do you think that mistake, like young lawyers make, is that they have to argue we've had different people talk about their style, and some people talk about it as a game, some people talk about it as creating a narrative, some people talk about the trial as a play, and it seems like you're staying in your own space, but you're also sort of working off of the others, and it seems like there's got to be some kind of balance on sort of how far you go on that.
I think everybody who's told you the things that they've told you are right. Mm-hmm. Okay, life is what you make of it. Right. Okay, if it doesn't fit, you adjust. I think it's key that you stand up and above everything else, be yourself. Whether it's a game, whether it's a play, whether it's whatever. I think the key to the whole thing is that no one is going to out Richard Davis. I'm not going to stand up and try to be somebody that I'm not. I think the other thing that's very clear is that you have to establish rapport. And when you listen to me talk, or when I present a case, you're going to know I believe in what I'm doing. I think that's very important. Mm-hmm. You can call it acting, you can call it a play, you can call it whatever you want to call it. But the bottom line is this. You can't convince anybody of anything unless they believe that you believe in it. And so I don't know, I don't never put a label on it, but I can tell you that whenever I'm trying a case, it's my stage, it's my whatever, because someone has retained me to represent them, and my job is to present the best case I can. And that's exactly what I'm going to do. And I do it as quickly, and you have to be entertaining to a certain extent. You have to be careful that you don't take liberties with the rules, because you still have to play the game, if you want to call it a game. But by the same token, you have some people up there that you want to listen to you. And there are ways of trying to do that, and you have to sometimes be a little entertaining.
Like in what way? Can you give us some
well, I don't want to go all my trade secrets.
Well, just one or two.
The problem is, one of the things that because I'm basically defense counsel, and obviously doing voir dire, a judge will ask a lot of questions, and a lot of people feel uncomfortable. I mean, some don't like expressing personal views in front of other people and so forth, and of course, but he goes on and on and on, and then since I usually represent the defense, I'm usually last in the process. So one of the things I do by starting out is making it very clear to them that, when you're last in this process, generally all good questions have already been asked. And so I can do whatever. But generally when I do that, I get a laugh. The bottom line is that, I let it be known that, number one, I've been listening with them. And number two, I'm not going to repeat everything. But, there are a couple of questions that I have to ask you. And if the answer is yes, please raise your hand and let's talk about it. That's something that I do. Now, like I said, you have to be careful because there was a time when lawyers did a lot of different things, and we got to the point where judges decided that we were abusing it, and therefore they would not allow us to do any voir dire. For example, there was a time when there'd be a panel, and I thought that there was this executive up there who I thought would be a good person. I'd look him in the eye and ask if he was asked if he would serve as foreman of the jury. Well, obviously that's not something that we like to do, and so I don't do that anymore. But the bottom line is, you do whatever you want to do. But I think the key to the whole thing is that we have ethics, we have things that we have to comply with, and the important thing is to try the case within the rules. but like I said, one of the other things I did, and I told you about that, is I learned from one of my early mentors that since juries sit around and wait, you don't want them to wait. I'd always get to the courthouse early. I'd stand in the door. I'd let them see me. I'd always want to let them know that if they're waiting, it's not because of me. That's part of the game. It's part of the process. I mean, so, you know, there are a lot of little things that we do to try to make it very clear that we're the good guy, or that I'm the good guy.
Did you know you wanted to be a defense? When did you decide that you wanted to be a defense attorney? Did you do that right when you got out, or?
Yes. Well, it's Chuck Ayers' hand again. I was very lucky as far as being a student is concerned. I did very well. And when I graduated in 1972, the question was, what am I going to do? Which is, you know, everybody else want to know, who am I going to go to work for? And my dad was not a lawyer. I didn't have a law firm, a job waiting on me, so I had to look around. And I had a couple of offers, but there was a firm in town called Chandler, Toledo, and Red Hair, and actually it was Richmond at the time, and they are one of the better known primary defense attorneys in town, and they were looking for a clerk. And Chuck asked me if I was interested, and I said yes, and so I went down and I interviewed, and I started to clerk for them my third year of law school. And after that, they offered me a job, and it was just so happens that that's what they did. I don't believe that there's any magic in calling yourself a defense attorney or a plaintiff's attorney. There are few people that probably fall into that category. I think a good trial lawyer is a good trial lawyer, because every time I put a case together, I put the plaintiff's case together, just like I put the defense case together, because I do things sometimes thinking about what they're going to do. And so I think being a good trial lawyer is a good trial lawyer. It just so happened that the nature of the business, I ended up doing basically defense work. I do plaintiff's work too sometimes. Not nearly as much, but sometimes.
You said that you're really busy now. I'm trying to get, this is kind of a muddled question, I'm trying to get a sense of how things have changed and sort of what you do when you first started versus what you do now. And you said that you were really busy now.
Yeah.
I'm sure you've been really busy all the time, but just sort of a sense of when you first got out compared to now.
Well, busy is a relative term, only because, you know, I put in an unbelievable number of hours. The nature of the work has changed. For example, very few trial lawyers start out doing medical malpractice cases and products liability. And the vast majority of my practice now is, you know, defending hospitals and doctors in medical malpractice work. I also do quite a bit of work for the city of Tucson, the state of Arizona, and others. When you first start out, you know, they're not going to turn over complicated medical malpractice cases to you. You're going to try what we used to call red car, blue car cases. I am one of the, well, I'm going to web the dinosaur, because when I started, we tried everything. I mean, the arbitration rules did not exist. We tried a lot of whiplash cases. I'm one of the few people who can sit before you and tell you that I've tried 400 jury trials to conclusion. You can't do that anymore, because a large percentage of the cases that I tried during my first 7 years would be arbitrated today. But I was trying 12 to 19 cases a year. But that was the nature of the beast and the way that we did things. And so I was busy, but the nature of the cases have changed considerably, because I do very few whiplash cases anymore. The vast majority of my cases involve very serious injuries or death. As a matter of fact, the last 4 cases I've tried have all involved death of individuals of one type or another.
Do you find that hard
Yes.
to deal with?
Yes. It's hard to deal with, but by the same token, it's something that needs to be done. Every case involving serious injury and death will have a time when it's very emotional, and it's going to happen, sometimes more so than others. But by the same token, on the other side of the coin, you have people who accuse of causing death and doing things wrong, and they have a right to be represented also. And so you have to put it together. But it's tough. I tried 6 wrongful death cases 1 year, and I look back and ask myself if I wanted to do it again, but then I answered that very quickly. I'm doing what I enjoy doing, and therefore, yes.
Why did you, I guess I want to talk a little bit more about that part. When you find that it's hard, what do you do? When you find, and sort of when when does it get to that emotional space? I mean, is it a different time for each does it always happen, or does it?
No, it doesn't always happen. You have to remember that you're dealing with people. And I don't care how you cut it. There are people that really, for whatever reason, reach out and grab you. And there are others that you can remain distant from. And I don't care what you do or how you do it. That's life. One of the things that you do in this business, particularly when you're a trial lawyer, is that you try to get to know the personalities of the individuals that you're dealing with. Same thing when you're striking jurors. You don't select jurors. You get rid of people that you don't want. But you have to deal with people. And I think at some point in time you have to get to the point where you can look at folks and say to them, you know, what happened to a person was tragic. But the question is whether or not you're going to satisfy or do something for people and create another tragedy by doing it. In other words, if you're accusing a doctor of committing malpractice and causing someone's death and they didn't do anything wrong, then aren't you really creating another tragedy by forcing this doctor to live with the fact or the claim that somebody claimed that they did something wrong and caused someone's death? It's a double-edged sword. And some people you can play that with very well, because there are times when actually the doctor is a victim. And there are times when, you know, when people die, you have to deal with it. And there's no way around it. It's tough. It's tough. It's a way of life. And, you know, there are not that many lawyers out there to deal with that on a daily basis, but I happen to be one of them. And you get to the point, you never become jaded, because I don't believe it's just another case. This is Dr. A's case. This is Plaintiff's B case. And you treat them all like individuals. You have to give the respect that's due, but you also have a job to do.
Tell me more about the respect that's due. What do you mean by that?
Well, every human being is entitled to a certain amount of respect. You know, I'm fond of using songs and philosophers and so forth to express things, and I've had people, you know, say things and accuse me of being one-sided or not caring or whatever, and my response is generally, you know, cool it. You know, there are no good guys, there are no bad guys. It's just you and me, and we just disagree. I think the key to the whole thing is that everybody who walks in that courtroom is due respect. And you don't have to get into a fist fight in order to establish, you know, prove your case. I have a job to do. I respect my opponent. As a matter of fact, every opponent I have is the best lawyer in the world. I have to teach, you know, treat it that way. Every case has merit. It's my job to walk in and establish my case and point out that my case is better than their case. But I never call people names. I never call people liars. If a jury want to conclude that someone's not telling the truth, let them. But that's not my job. I don't bully people as a rule, and I think that that's kind of what I mean, because it's part of a philosophy because of this. Juries do bad things to people when they either don't like you or they really feel sorry for the other person. And if you stand up and make a jerk of yourself and it costs your client, then you've done something wrong. And I never want a client of mine to have an adverse ruling because I did something wrong. And that's really what it's all about. It's about respecting the system. Every time I address the court, I always stand, and it's your honor. If I get an adverse ruling, I'm never going to whine or do whatever in front of a jury. The court has ruled, I'm going to live with it. I've never filed an affidavit against a judge. My position is I'm going to try my case. I know what I'm doing. As long as the judge can either understand or appreciate the law, I'm going to do all right. And if I don't believe in it, I'll take it up to the Court of Appeals. But that's what I mean about respect.
Do you feel that others don't do that? I mean, do you feel like you're battling with a world that doesn't have the same value system?
That's a tough question, and if I wanted to take the fifth, I probably should, but I'm not going to, because I think that there are some people who don't share that philosophy. At least they don't practice it, but there are not a lot of them. And the important thing is that I don't do it, and that's one of the reasons why I think that to a large extent I have the respect of the judges practicing down there now.
You have a respect of lots of people. You're one of the people who your name kept coming up over and over again. People we should interview for a variety of reasons. Maybe we could talk a little bit about that, because it seems like reputation is really, really important. We hear that over and over again, and that's part of what you're talking about.
Yes.
And is that, I guess, one of the things is reputation is doing right and being good and being respectful, but is also sort of, there's a personal philosophy and sort of your belief system that comes into your reputation as well. I mean, it isn't just a surface politeness, it
Right.
seems like. It goes deeper than that.
It goes deeper than that. I think it goes to being honest. It goes to recognizing that when you have a rule of law against you, you bring it up even if the other side does not. I've been in court on occasion when my opponent was not aware of a case that was favorable to him and against me, and I've called the court's attention to it. I think I should. I think I have to. And one of the reasons for it is that, it's the right thing to do. And secondly, more than likely it'll come to light anyway. And so when you do that with judges and when you're candid with them, and you never lie, I think you walk in there, you treat everybody with respect, you don't lie. You're an advocate, and I will tell you, there's no one that will fight for his client more so than I will. But I'm not going to walk in there and lie for them. I'm not going to walk in there and advocate a position that I know is contrary to the law, particularly when I know what the law is, and so forth. And I think if you do that, you're going to do all right. That's where reputation comes in. And one of the things that I think makes me feel great is that when I walk into a courtroom and people from out of town and other places walk in and they're going to show us Hicks how to do it, and after they're all said and done, the judge look at me and say, well, what do you think, Richard? Because the bottom line is they know, number one, I'm not going to blow smoke. I'm either right or I think I'm right. At any rate, I'm not going to advocate a position that's totally off base. And, like I said, once the judge rules, the judge has ruled. And I'm not going to do anything to try to undermine that or deliberately try to create a mistrial or whatever. And that's why I think I enjoy the reputation that I do to the extent that I do.
All right, I got 1,000 questions from what you just said. Every case has merit, and then you said stuff about clients and advocating, and then we had talked to a prosecutor, a young prosecutor, about she saw her role as justice, and she said it's not about winning, but then she feels kind of bad if she doesn't win. I mean, that there's sort of that mixture, and sort of how do you get all the? I mean, it seems like you're just pulled in all these different, and that's just part of the job. Does that seem like, or can you figure out how you? Do you know what I mean?
I understand. I think I do. And let me try to answer it this way. You are pulled, but by the same token, I can honestly say to you that 99.9% of the time, I honestly believe that what I'm doing is right. Okay? And that's very important. That's very, very important. Every once in a while, you come with a situation where you're not sure. And for that reason, I really advocate my position, advocate it very strongly. I am like everyone else. I don't like to lose. I don't like to, if I'm playing marbles, I don't like to lose. I think that, there are times, though, when our definition of loss is really distorted. And what I mean by that is this. If I have a case where I'm representing someone who rear-ended someone and injured them, and we walk into the courtroom, if I pull that off, that's not a loss, that's a miracle. Sometimes it's a victory because of the amount of money that you're talking about. If I think the case is worth $50,000 and they're asking for $1 million and the jury come back with $50,000, that's a victory for me. I mean, you can't prevail outright. But by the same token, I've done very well from a standpoint of prevailing in cases that I try. And I think it's because I really believe in the cases that I have. Now, you need to understand something, too. We have cases, and we settled quite a few cases. I think that we do a pretty good job of figuring out those cases that we should settle. And so when I get to the point that I'm going to try a case, you can rest assured that it's because I believe that it should be tried because I think I'm right. And I think that, that is something that you have to factor in, because there are a lot of cases that I end up resolving by settlement that I know that chances are if we tried it, we wouldn't prevail on it. And there are cases, believe it or not, where I'm convinced that my client did something wrong. And on those cases, I try to, resolve them.
Resolve them by
settling.
By settling.
Mm-hmm.
How do you? We've had a lot of things about difficult clients and sort of when you meet with a client, is that something that you're looking at? How do you decide what kind of client if you're going to take the client's case or not? And does, I mean,
Well, that question really has to be, I think, customized or pointed at particular individuals, particularly people who I call plaintiff's work as opposed to people who do defense work. For example, if I represent University Medical Center, it's kind of hard for me to say, okay, if you're going to send 12 cases my way, I'm going to look at them, and if I like 10 of them, I'll take the 10, but I'm not going to take the other 2. They're my client, and they won't cease being my client. And so I don't have the difficult client situation that I would have if I had 15 or 20 individuals coming off the street, and I have to deal with all those personalities. I mean, I deal with institutional clients mostly. I mean, my hospital or my municipality or whatever, the University of Arizona. And so I have the problem with difficult clients. Now, every once in a while, a person will come in and want to talk to me, and I will talk to them, and there are times when I simply refuse to represent people. There's a case in point. If an individual has gone to 3 or 4 different lawyers, they've all turned him down, it's a pretty good indication that there's nothing there, and you're better off not to get involved. There are people who come in and know all the answers. Well, if they know all the answers, no matter what I do, if I don't get them the result that they are looking for, then obviously I have not done a good job. So it's one of those things where if I'm asked to represent an individual, and I am on occasion, I size them up and try to figure out what they're looking for. Now, it's good to be in a position where you can afford that. And I have refused to take cases because I concluded that after meeting the client, it's a no-win situation. Because unless I get them exactly what they want or more, it's going to be a bad situation. And so we all have those, but I don't have it to the extent that a lot of lawyers do.
did you have it earlier in your career? Did you feel sort of in a jam because of a client?
Not really, but see, part of the problem, I told you once before, I don't necessarily like talking about me. Some of the things I've said today, people have never heard. I got lucky very early on, and the reason I put it that way is I was out of law school for a year and a half when I was asked to represent the city of Tucson in a case involving water. We had 2 subdivisions in town that claimed they were getting water that was causing their pipes, copper tubing, to pit. And I'm out of law school for a year and a half. My senior partner, Judge Tuller, had the case, but I did all the work. I worked with the experts. When they came up for trial, Judge Tuller said to the city, I could try this case, but that kid's done all the work, and he ought to do it. Now, you have to remember, all of the copper companies were defendants. Anaconda, Phelps Dodge, and they were supplying the copper. And we had all these homeowners out there, all against the city. Well, I tried that case, and we won it. And this is 1973. And from that day on, the city of Tucson has been a client of mine. I never had to go out and do anything else because they've been a client of mine. And so that's luck. And so I didn't have to go out, doing this, that, and the other. I went on the roll to do a criminal work at one time. I represented a young man who was caught smuggling drugs across the border. I was able to convince folks that the search was illegal. We got him out on a very, very, very minor deal. But 6 months later, they called me back and said, guess what? We've got the same guy, same thing. And I said, time out. This is not my cup of tea. I don't need it anymore. But what happened was I was lucky enough that I started representing people to the point that I didn't need to do that anymore. And so I guess what I'm trying to tell you is that I got lucky and picked up some clients early on, and from that point on, I never really had to worry about, clients or where they came from. They've been keeping me busy. And the city of Tucson is still a client of mine. And it's kind of interesting because the city is not one of the better paying clients, but I still work for them. And the reason for it, I was a scrapping lawyer in 1972 with wondering where I was going to go, and they believed in me enough to give me a shot, and I've never forgotten it. And I will tell you, until the day I hang it up, they'll be a client of mine as long as they'll have me. But that's the way I operate. Because, like I said, from that day on, in 1973, a year and a half out of law school, my career was really made as a trial lawyer. And that's because somebody had guts enough to say that I'm going to let that kid try my case.
That's really cool.
Yeah, that's fact.
How do you, any advice about long-term clients? We hear a lot about short-term clients. It's hard to keep, it's hard to keep friendships going for a long term.
Well, I've been representing the same basic people now my entire career. One of my other biggest clients is Tucson Medical Center, and I've been doing work for them since the mid to late 70s. It's all a matter of doing good work, doing what you're doing, and being honest. And when you have to be, be a little firm to let them know that you know what you're doing. And if you have a bad case, you get rid of the bad cases. You try the good cases, and it's just one of those things where I don't know why. Maybe I ought to knock on wood. Maybe I'm just plain lucky. But most of the clients I've had for a long, long time. And I understand that because there are some clients out there with the philosophy of what have you done for me lately. I think I've been lucky from the standpoint that I probably get better results than I should on most of my cases, and I work hard, and I'm always there.
What do you mean by always there?
Well, a client is a client, and they deserve your attention. They deserve your respect. They deserve to know what's going on. I have a staff and I have a philosophy. If you call my office at any time, day or night, and there's somebody there, somebody can tell you the status of your case. My secretary, my paralegals, my associates, we have regular meetings. They know what's going on. And if they need to know when the trial date is, we'll tell them that. If they need to know where we stand with discovery, they'll know that. To know whatever's happening, they know that. That's kind of the way that I operate. If I'm working with a hospital and doctor, and even if there's an insurance company involved, I think the individual whose case it is has a right to know what's going on. So I keep them all apprised of what's going on. That's kind of what I mean.
Do you think we've had a lot of people talk about, said that you put in long, it kind of goes with this long hours, sort of the dedication to your work. Do you think that you can have, I haven't asked you this part yet, but do you think you can, do we need to stop? Is it okay with the noise?
No, it's
fine. Okay. Do you think that you need, this whole question of balancing life, or people who have kids, or illnesses, or sort of, can you be a lawyer if you can't put in all those hours?
Sure. I mean, when I say all those hours, I mean, I guess it's really relative. Now, don't get me wrong. I think that when I'm in trial, the day is usually 12 to 15 hours a day. And there are times when I put in those hours on a regular basis. But by the same token, you have to find time for yourself. You have to smell the roses. I think you owe something to your family. You owe something to your school. You owe something to your community. And I have always thought that it was important that if you were in a position that you ought to serve on boards, and you have to do whatever. I have served on literally, well, I can't say every board in town. I mean, I was on the Legal Aid Society board for 19 years. I've been on the Alumni Association board. I've been on the board of visitors. I also believe that when you believe in something, you ought to be willing to give your time. For example, back in the 70s, there were questions raised about whether or not the bar exam was not ethically, but culturally biased. And for 7 years, I drafted questions for the bar exam and graded them. And the reason I did it, because if it was culturally biased, it wasn't going to be with me. I mean, I did that. I served on, I was on the first committee on character and fitness. I did that for 7 years. I've taught trial practice here in law school. I've been on the board of the Red Cross, the YMCA. I'm on the board now of the Urban League. I mean, I've served, and you have to do those things. And to me, that's very important. And you can find time for it, no matter how much time you spend in your law practice. And then family come first. And so, to answer your question, yeah, you can do it. Is it difficult sometimes? Yeah. But it all boils down to how important it is to you. And I balanced it. There are sometimes when I wonder how, but I've done it.
Why is it important to serve on those boards?
Well, because, you know, I believe that there are not a lot of people out there who have accomplished everything because, you know, they're so good and you've done it on your own. I've always had somebody to stand up and give me that extra push when I needed that extra push. I've always had people, you know, like Chuck Ayers, who's provided that little spark when I needed that little spark. And I think it's really sad if I would not go out and do the same thing. And so I belong to a fraternity. Every year we sponsor a program, go to high school, go to college. Every African American who happens to be a freshman on up, we bring them out and we talk about the importance of education in college. I sponsor a program every year where I in my fraternity, pay homage to all the African American males in town that have excelled academically throughout high school. I don't do it for women because the sororities won't let me. But, you know, those are things that you do. I mean, you know, Charles Barkley said, I don't want to be a role model. I think I am whether I want to be or not. And people see me, and whether I'm a good one or not, I leave that up for the people. But it seems to me that when people talk about what I've done or how I've done it, it's key that people know that I'm a human being. And if I can help somebody along the way, then I think I ought to do that. That's why it's important to me. And if I had to go back and draw a list of people that helped me get to where I am, it'd be a very, very long list. For example, Judge Tuller taught in the city, and they're letting me try that case. He didn't have to. You know, Chuck Ayers with the law school, my English teacher who did whatever. You know, the point I'm making is that it was just somebody who felt that, hey, I'm going to do whatever to encourage Rich Davis to become all he can be, and I think it worked. So I have to repay that. I have to repay that.
Do you think that's true of every person? We hear that a lot with lawyers, and that life has been good to them, and the law has been good to them, and that they have a duty owed back to all the people who helped. Do you think that's true of everything, or do you think it's specifically lawyers?
I think it's true of everything. I don't care if I would have been a doctor, a lawyer, or an Indian chief, or a garbage man. I think the bottom line is that if you have something to offer, you ought to offer it. And I think a lot of people who are not lawyers have something to offer. I know a lot of people out there who don't even have a college education, but who have certain talents and the ability to you know, assist people and help them accomplish something. And I think that's, everybody owes that. I hear people say all the time, I paid my dues. You never pay your dues, as long as there's somebody out there that you can help. Now, I can be a hard taskmaster, because I can tell you that if you're not out there taking care of business, if you're loafing, I'll tell you. If you're not on the job, I'll find somebody who is. But by the same token, if you're really trying and you need a little help, you pick up the phone, and I will tell you that either I or my wife or somebody else will be there. That's kind of the way we've always been, and I think that that's one of the reasons why I think I enjoy part of the reputation that I do. I'll fight you. I'll fight you fair. And when it's all over, I'll pick you up and I'll put my arm around you. And if I can help you get better, it's fine. I'm just not going to teach you everything I know, because I want to win. But no, that's a little. I don't want to take it.
Okay, we've asked a lot of people. I'm going to switch down. We're going to run out of time, so I'm going to do a couple crazy questions.
Okay.
Well, maybe these other ones have been too. I ask, and I seem to, because you're towards the end, so
Okay.
I've asked a bunch of people if they're scared of their clients, and a lot of people usually say no. And I think I'm just mostly a scaredy cat. So I was going to ask you too, if you've been scared of your clients, and also if what you learn about your clients, like in the medical stuff, scare you. That if you look at things, or you're more frightened about the way the world works because of what you've seen, or if it gives you more confidence.
No, I've not been afraid of a client. I have to admit that there have been times when we've had clients come in who have actually been a little belligerent and done whatever, but usually that's not something I've been faced with. one of the things I really enjoy is that I learn so much all the time. I'm constantly learning. For example, when I represented a certain hospital in town and there was a claim of concerning pacemakers, I got to the point where I learned all there is to know about pacemakers, and I swear I could implant a pacemaker. I do, when I'm in an OB case, I can tell you, I can do a cesarean section, but I've never been in the operating room to do one. When I'm representing, architects and engineers, I can read blueprints. I can do those things because you have to in order to represent your client. And to me, that's kind of what this is all about. It's a constant learning process. And every day we get a new deal to come in. And usually you have to remember, I've been very fortunate because most of my clients come to me. I don't advertise, and although I know it's legal, I don't believe lawyers should advertise. So I'm in a position at this point where 95% of my clients come to me because they want me to represent them, and it's been that way for a long time. So in that regard, I've been very, very, very lucky. So I'm not afraid of them. Mm-hmm. There are some that have come in that I've chosen not to represent for various reasons, but generally it's because I'm too busy, or it's because the case is either something that I don't believe fall within my expertise, or it's a case that I don't believe in. But no, I can't ever say I've had a client that I've been afraid
of. What about billing? You said that, how do you handle billing, and how strict are you with your clients about billing? We've had the whole gamut.
Yeah.
And do you have any thoughts about billing and how it, or any, do you want to talk,
Well, I don't, I really don't have anything to say. I mean, the real problem with billing, and again, you have to look at what a person does, the nature of the practice, and so forth. I mean, if you're a plaintiff's attorney, for example, you're going to probably use a lot of contingency deals. I don't do a lot of that. You don't pay if I don't win and that sort of thing. The vast majority of my work is hourly, and I can say that in all the years I've been doing it, I've never had anyone stiff me on a bill. And like I said, at this point, when people come to me, I very seldom have that kind of a problem. So I'm not sure that I can add anything. If you have something specific, I'll try to address it.
Do you think that's because they're institutional clients, that they may be slow in paying their bills, but they get around to it? Or?
I think that's probably true. I think institutional clients are easier. They may not pay as much or the way we'd like them to, but they generally pay. Now, I do some plaintiff's work, and I take a contingency, but I think I'm very careful in that. I can't remember the last time I took a case that didn't have merit and we didn't recover, but I don't recall having a case where I had a fight with a client about a bill. And if I'm lucky, I'm going to count my blessings and knock on wood and hope it continues, because that's really terrible. I mean, that's one of the toughest things that you can run into, because it leads to complaints with the bar, it leads to uneasy feelings, it leads to a lot of different things, and that's why you need everything. If you're going to have any questions like that, contingencies should be in writing, and you should keep people apprised of what's going on, because the last thing I want to do, I honestly believe that I'd walk away from something like that before I'd fight with a client over billing. And again, I have to admit, it's because I've been lucky.
All right, these are random because we're getting to the end. Spirituality and your philosophy, your personal philosophy of life, or how your parents raised you, or how your wife raises you, or your children raise you, and how you practice law. Do you think they're separate, or do you think they all go together?
I think they all go together. I think we can separate them to an extent, but I think there's a common thread. For example, I chose my parents right. Okay? No, my mom died when I was 9. And my oldest sister was 12, and there were 6 of us. And my oldest sister became my best friend, my mother, and my sister. And my dad had a 6th grade education, but all of his kids had college educations. I remember when my oldest sister left school, left home to go to college at Tuskegee Institute in Alabama. And I remember my dad borrowed $200 from Dow Finance. He had 4 $50 bills, and he gave them to her when she left for school. And about a month later, she sent 2 of them back in the mail. It's one of those things where I've always had a situation where we are told that if you work hard, you're going to do all right. If you treat people right, you're going to be all right. If you have a God-given talent, you ought to use it. And you never forget family. And you never forget where you come from. And you never forget that there's something out there that's all more powerful than you can ever be. And you will never know all the answers. And that's why I think everything lives together, work together. Because like I said, I feel that I have to reach out to people to help because people have always reached out to me. And that starts at home. It didn't start with Chuck Ayers. It started at home. And so it all works together. But I've always been told that you do the best you can, things will work out. And I've always been a hard worker, and therefore it doesn't bother me to work 12 or whatever hours. But when it's all said and done, I will go home. I will prune my roses. If I have to, I'll cook dinner, and we'll do whatever we have to do as a family. But I think that's kind of what life is all about.
That was really nice. Wasn't thinking of my next question. Sorry, you got me all flustered.
Well, I hope I didn't mean to do that.
No, in a good way. It's in a good way. It doesn't happen very often. Okay, here's another one. The Practice. I don't know if you watch it. The show The Practice. Do you like it? Do you hate it? Do you think it is good for the law to have those kind of shows, or do you think it's bad?
I don't. First of all, I don't think I've ever seen The Practice from beginning to end. But I have watched the show Law and Order, and I do enjoy that from time to time. I will tell you, there's something very interesting about TV shows that I find very, very fascinating. Have you ever noticed that folks get up and do a closing argument in 5 minutes or 3 minutes, and how effective they are? Have you ever noticed how they get up and do a cross-examination in 3 minutes and how effective they are? And you have to remember, you learn when you're dealing with people. We are in a visual age, so when you're trying a case, it is not uncommon then, in my opinion, to put up a video and do whatever, because that's the way people are. And you learn and you adapt. For example, if I'm talking about the triage, and the triage nurse taking care of a patient, well, it doesn't hurt for me to refer to MASH. And what they do when the guys come in from the front in the ambulance, and how they get in there, and how they look at everybody, and how they try to determine who's the sickest because they're going to be seen first. Well, that's a concept that they're familiar with. And so I learned from that, because I will tell you that if a person can get on TV and make a closing argument in 2 minutes and cover the points, then doggone it, why do you need an hour and a half to cover the same thing? That's my point. Concentrate on the things that are important and get your point across. And so I think you learn from it. Now, The Practice is not one that I have looked at, but I've looked at others, and like I said, Law and Order, particularly when Rich Moriarty was the DA, I liked his character. I'm not so sure about Sam Waterman, but you learn those things because people watch it, and you use it to the extent that you can, because you know that when you're dealing with people that watch that, you can make your point, and rapport and identification is what you're really concerned about. Okay, and so good, bad, indifferent. I generally think that, most of them aren't, but you learn from them, and you take advantage of them to the extent that you can.
How are we doing on time? We're doing okay. I have 2 more questions. Is that
Shoot.
okay? You had said something about being local lawyer and other lawyers, out-of-town lawyers coming in. Do you think with all this nationalization of firms and sort of the local, sort of place of the local, it seems like we've interviewed a lot of Tucson people versus Phoenix, but it's part of law for so long. It's been about reputation and relationships, and what happens when that is gone. Or does it work differently, or?
Well, I don't know.
Yeah.
It hasn't happened. I hope it doesn't. We've seen it happen with banks and other things where they nationalize. You have to remember that, most of your large corporations nowadays have counsel that do their work nationwide. For example, Hyundai, has a firm that does all of their work all across the country. But when they have a case here in Tucson, they have to associate local counsel. And so they call me and work with me. And I think that that's what most of them do, because they don't know the local flavor. Number one, they may not be admitted to the bar, and if they are, then they still don't know the local nuances, they don't know the judges, and so you do want that local flavor. So I think that no matter what happens, they're going to continue to associate local counsel just to help them out a little bit. I know the judges. Some of them I practice with, some of them I've been around. I know what they like, I know what they dislike, and if you're from out of town, and you don't know those things, you could be working at a disadvantage. So my guess is that we won't see, at least not in my lifetime, nationalization to the fact that we cut out the local people, because if you do, I think you're working a big disadvantage. Because, you know, when you walk into the courtroom and you say Ajo instead of Aho, they know you're not, you know, you're not at home.
Right.
There's just a few things you need to know. And we won't make those mistakes. So I think that that's the way you work around that.
All right. Before we turned on the tape, you were talking about the bar exam and the calluses that you got from the bar exam. Could you tell us a little bit about the experience of the bar exam when you said real people took the bar exam?
Well, you know, like I said, I took the bar exam in 1972. And at the time, it was a 75 essay question exam. It was an exam that lasted Thursday, Friday, and Saturday. 30 questions on Thursday, 30 questions on Friday, and 15 on Saturday. And they were all essay. And it's not unique, because everyone before me and several years after, that's the way it happened. Now they've gone to the multi-state. Well, I stopped drafting and grading questions before they did that. But I wasn't kidding with you. I've got some calluses right here on my hand that I developed when I wrote the bar exam out in 1972 that simply have not disappeared. But I just do that to kid people now because of the multi-state and all that. You know, it was one of those things where I always thought that because law is really, in my opinion, issue identification and factually driven, that essay was a good way, you know, to handle that. I don't know how they do it with the multi-state, but you know, it's not my cup of tea, and I'm not being critical. It's just that it was just a difference that I noticed, and when we were making light conversation, I mentioned that to you. But it's true, the calluses and the essays. Okay.
Do you want to get the questions before I ask the last question? No? Happy moments in the law. Happiest moment in the law can be anything.
Wow. Happiest moment in the law. Believe it or not, well, I'm going to give you a happy moment. It has a little something to do with the law. I have 2 kids. I'm one of those people who at the time thought that, boy, if I was in a room with a lady giving birth, I'd fall over. I was maybe hitting my head and splitting it open and all those different things. And but my wife decided that she would have natural childbirth and would do it the Lamaze method. And of course, we had the baby at TMC. And I went out to the hospital with her, and we were playing cards, and I'd see all the other people in there moaning and, you know, calling their husbands' names and all, and they're not there. LaRonda's born. I had to hold my baby before my wife did. Everything's cool. I leave there, and I rush over here to the U of A to teach my trial practice class. And actually, that was one of my best moments, because I tell you, we got through that class, everybody was applauding, and I don't remember what I said. Okay, but that was probably one of the best moments, and it has nothing to do with well, it has something to do with law because I was teaching law. But I think that one of the best moments I had, and there are several, but I will tell you one, and it scared me after a while. Remember the case I told you I tried for the city? Mm-hmm. I left the courtroom. When I realized what I'd done, I walked out of the courtroom, and I just jumped in the air. Now, if you've seen the Superior Court building, it's kind of high. And I was in the middle of the air, and the sidewalk is down here, and I didn't realize I had jumped off the side of the building. But I was so happy. I mean, you know, it was one of those things where, you know, first of all, it's a career breaker, it's a career maker. And from that point on, everything was happy. But I just blindly just leaped into the air, and I didn't realize what I'd done until it happened. But anyway, that's true.
That's pretty good.
Yeah. I survived it too. I mean, I didn't even sprain my ankle.
That would be terrible.
I didn't even sprain my ankle.
Well, before we end, is there anything else you'd like to say, or thoughts, or any advice? Or?
Well, you know, I don't, because you know, life is an interesting situation. I think the key to the whole thing, though, if I had to give somebody advice, if you twist my arm and make me do it, it's not take yourself too seriously. You know, you have to understand that life is life. I don't care whether you're a lawyer or whoever or whatever you are. It's a job. It's an avocation. You have certain things that you have to do, particularly if you're a trial lawyer. You have to be an advocate, but you don't have to be mean-spirited. You don't have to treat people like they're something less than human. You don't have to get into a fist fight to be a good advocate. You don't have to try to destroy people to get your point across. But more importantly, just remember that you're a human being and that you have a life to lead. You have family, and you have a community out there that I think deserve the best that you can offer. And if there's one thing about me, I don't have much of an ego, and I never take myself seriously. I've done what I've done, but largely it's because, like I said, I chose my parents right, and I have good people leading the way. Everything else has fallen into place. And I've always believed that if you work hard, if you do the right thing, you'll do all right. And I am fond of saying that I'm lucky, but I also think that the harder I work, the luckier I get.
That's pretty
Okay?
good. That's good.
That's it.
Thank you so much.
And that's unrehearsed, by the way.